Are Google, Facebook, Twitter helping spread the tentacles of terrorism? Are social media behemoths aiding and abetting terror? Do they enjoy complete legal immunity from such allegations just because they are tech giants and the laws meant for them are different from traditional media? These are the questions that are going to shape the future of the internet and social media giants, and these are the very questions that are in front of the Supreme Court of the United States. The SCOTUS began hearing oral arguments yesterday in a case that could perhaps upend the protections internet companies have had throughout the roughly 2-decade rise of social media. In this video, we tell you about this landmark case that is in front of the apex court of the USA and the fate of which might ultimately decide the fate of the social media giants. But before that, don't forget to like, share and subscribe to Oneindia. In fact, there are two cases that seeks to find legal answers to all these questions. The first case is Gonzalez versus Google. In this case, the family of an American college student killed in a terror attack in Paris has sued Google over claims that its video platform YouTube's recommendations algorithm helped extremists spread their message. There is also a second case, which is Twitter versus Tamne, that also focuses on liability, although its grounds are a little different. It involves a Jordanian citizen killed in Istanbul and its family accusing Twitter and other social media giants of accentuating ISIS influence. Gonzalez versus Google primarily centers on allegations that Google subsidiary YouTube provided a platform for and used its algorithm to recommend terrorist content in a way that incited violence and led to the death of US citizen Noémie Gonzalez during a 2015 terror attack in France. It targets the controversial Section 230 of the 1996 Communications Decency Act, which provides a liability shield for internet providers over content posted by third parties. The court will decide whether an individual or a group of individuals can sue Google or other social media giants for promoting extremist content through their algorithm. In the question is Section 213 of the 1996 Act. This is basically 26 words stuck into a law overhauling telecommunications that have allowed companies like Facebook, Twitter and Google to grow into the giants they are today. The essence of Section 230 is this: if a news site falsely calls you a swindler, you can sue the publisher for libel. But if someone posts that on Facebook, you cannot sue the company, just the person who posted it. Its wordings in the bare act goes as this: no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. This legal phrase shields companies that can host trillions of messages from being sued into oblivion by anyone who feels wronged by something someone else has posted, whether their complaint is legitimate or not. Section 230 also permits social media services to moderate their services. They can remove posts that, for example, are obscene or violate the service's standards. There is another simple way to look at Section 230, which is this: the main thing people do on the internet is to communicate with each other, and a lot of that communication is made possible by Section 230. But the law says that tech companies that permit people to communicate are not responsible for the discussions and its effect. Their liability ends with only hosting those communications. But the Gonzalez case, rather than focusing on the hosting of content, will consider if Google is responsible for its algorithmic recommendations that drives content to users. Google, on its part, argues that its recommendation algorithms are essential to operate the modern internet and that the US Congress envisioned Section 230 as protective measure. It has also claimed that weakening protections to companies would make it more difficult to provide relevant and safe results. Section 230, however, does not protect sites that violate federal criminal law or intellectual property law. It also does not protect platforms that create illegal or harmful content. The result of this case can highly impact the future of free speech and expression on the internet. And if the case is ruled in favor of the prosecution, the entire gamut of online communication and the liabilities of the companies will change. For better or for worse, that's the question, the answer of which lies in the future. This was all about Section 230. We hope you will like this new video. Thank you for watching.
Subscribe to Oneindia channel and never miss an update.